You're good to go.
All right. Good afternoon. I'm Janet Wall. I'm the CEO of the Virginia Nurses Association and the Virginia Nurses Foundation. And I'm so glad to see you all. Thanks for joining us today to discuss the new COVID-19 retroactive workers' compensation law that goes into effect on July 1, 2021. As many of you know, this new law is a result of a lot of hard work from VNA, our bill sponsor, Delegate Chris Hurst, and the many nurse advocates across the Commonwealth. Please note that today is for educational purposes only and should not be considered legal advice. We ask that if you have a question, please enter it in the chat box. If you would prefer to ask your question privately, please send a private message using the chat feature to Kristen Jimison. And in a moment, we will begin recording, and actually we've already done that, and after editing out any sensitive information or questions, we will post to our YouTube channel and website. We're pleased to welcome Craig Davis of Reinhardt Harper Davis and current president of the Virginia Trial Lawyers Association, and Casey Ariel, a founding partner at River Run Law Group and the chair of the Virginia Trial Lawyers Association Workers' Compensation Section. We will start with a brief introduction to the new law, and then we'll be happy to take your questions, beginning with those that were submitted ahead of time at registration. And with that, Craig and Casey, I'll let you take it away. Thank you so much.
Thank you, Janet. Casey, Ariel, how is everyone today? I just wanted to start by saying thank you for joining. It's a very important issue. You all have been on the front lines of the entire COVID-19 issues this whole past year, and we, other than wanting to help you understand some of these nuances, want to thank you for your contributions in that area. First and foremost, please feel free to ask questions in the chat feature. I don't have a ton outside of the FAQ to go over unless you need me to. I also don't want to go too deep into any of the legalese, unless you all are interested, which I highly doubt. But anyway, Craig, if you wanted to just say a few words yourself too, go ahead.
Yeah, thanks, Casey. And again, my name is Craig Davis. I am the president of the Virginia Trial Lawyers Association. In addition to representing over 2,000 lawyers who all represent individuals in workers' compensation and personal injury cases, we have a very robust lobbying team, and we generally get behind and support bills that are important to our members. I myself spend a lot of time and a lot of my practice is doing workers' compensation. So once COVID hit, we knew this was going to be an issue. And also being president, and at the time COVID hit, being president-elect of VTLA, our first step in this process is we approached the governor, and we thought that there could be an executive order that made these, well, let me back up and say that. I think as the workers' compensation laws were written a year ago, we did not believe those laws would find COVID-related conditions to be covered by workers' compensation for healthcare professionals. The same is true for first responders. So we identified that as a problem. We went to the governor's office and asked him, along with the many other executive orders he entered, to enter an executive order that found these conditions to be covered under workers' comp for medical professionals and first responders. The tepid response, I guess I'll say, we got from the governor's office was this is probably better handled through legislation. There was a emergency session or a special session held last summer, and we presented a bill. We had someone to carry the bill for us. We thought everything was good. And then the arguments broke out. And it was, well, if we cover police and we cover healthcare, then we have to cover teachers. If we cover teachers, we have to cover people in grocery stores. If we cover grocery stores, and then the old saying is the perfect becomes the enemy of the good. And what we were left with was, at that point, no one wanted to go forward with the bill to cover who we first intended it for, being, again, healthcare professionals and first responders because other people would be left out. And then the thought was if everyone was included, it would fundamentally change some budget issues at a time when everybody thought the budget was going to be in a lot of trouble. So the special session came and went with no bill. And at that point, we pretty much thought this is something that's never going to come to pass. Lo and behold, it comes back this next session with the retroactivity provisions. Casey will probably go into this a little more detail in a second, but 2 bills were actually passed, one for healthcare professionals and one for first responders. And they had a few differences and ultimately both passed, and they were combined to have a similar application. As of now, they both apply retroactive, which means, again, if you got COVID back when COVID was ravaging our state and the nation, it should apply. It remains to be seen. I may have a few more comments about that later on, but I'll let Casey go forward and discuss what exactly the bill covers.
Yeah, sorry, my phone's ringing off the hook here. But yeah, so first and foremost is talking a little bit about this is who does the new law cover? I think most of the people on this call are nurses registered or otherwise. And so you can be rest assured most of you will be covered. The definition's rather long of what a healthcare provider is in the statute. A lot of it is kind of not relevant for your purposes, but it covers a wide swath of folks in the healthcare field. The person who is a healthcare provider has to also be directly involved in diagnosing and treating COVID-19. And last, obviously, has to have a positive diagnosis of COVID-19 and symptoms that required medical treatment. One interesting part of the bill is who is not covered. We know that this is kind of a hot button issue for people all across the nation right now. But if your employer has offered you a vaccine and you refused, and you're not already immunized or have a serious health risk that it poses, this presumption, this bill will not cover you as written. So that's something to just keep in mind for folks. And again, we all have different thoughts on these vaccines. You all know far more about the medical piece of it than I ever will. But that's just kind of what we're stuck with as worded. Why is this new law important? What does it provide? Well, first of all, you could always claim in workers' comp exposure to COVID-19 as a condition that you got at work. The reason that was going to be very tough for medical folks in particular is because, as we know, you could be exposed to COVID outside of your work hours, outside of your work duties. And so how the law before this bill and how it's always been interpreted is that a disease that is you're exposed to equally to the public is an ordinary disease of life. What does that mean? That means you can be exposed to it in any other fashion, shape, or form outside of your nursing duties. And so the concern is if it is an ordinary disease of life, you have to prove by clear and convincing evidence that you got it at work. Long story short, it's a really, really big hurdle to get over in order to get it covered, because you got to prove that you got exposed to it at work and caught it at work. Well, this new law adds a presumption. So there is going to be, it's going to be presumed that if you have presented with these symptoms and have a positive diagnosis, that you did in fact get it at work and you were exposed to it at work. Once you have that presumption, it is rebuttable, meaning there can be evidence proffered against that presumption, but it's pretty strong presumption. So you start from a better foot forward. If you are awarded these benefits, it comes with what workers' comp always comes with in our world. And again, I'm not sure if any of you have had to navigate the workers' comp system, but it can be rather labyrinthine sometimes. But essentially, there's 2 big benefits that you would get, and this is under 2A is a lifetime medical award, meaning they have to pay for any and all causally related treatment as a result of your disease of the COVID-19 exposure, and also wage loss replacement benefits. And the reason that's important, it's 2/3 of your average weekly wage while you're out of work as a result of COVID-19 and the time that you're out for any reason related to that. One odd part about the law is going to be this retroactivity issue, and not to get too wonky into the substance of it, but there's going to be some questions about whether or not this will uphold under constitutional scrutiny in Virginia. But for your purposes, basically it applies from March 12th, 2020, so last year when all of this kind of started, so to speak, until December 31st of 2021. And the reason that they did that, I think, and Craig might have more of an insight on that, they had to kind of pick some dates where, it started and then you had to have some sort of end date in terms of the presumption, I think, in maybe the horse trading back and forth. I also think by that point in time, a lot of people, especially in the healthcare field, were getting vaccinated. So I'm assuming that had something to do with it. But regardless of why, yeah, go ahead, Craig.
So Casey, the first date, the March 12th, that was the date of the first executive order that the governor had that put us under a state of emergency. So that was the start date for it. And then I think July 1st was decided as, by that time, people who wanted to be tested could. I think up until that point, it had been a fight for tests, and you were calling around and people had a lot of problems. There weren't enough tests. And so that was just sort of the date decided on, that by that point, if you needed a test, you could pretty much get one without waiting weeks. And they were more widely available. But I don't think it was any magic to it other than that.
Yeah, and relatively arbitrary to some extent. But the big difference is they split it into two different kind of sections. So again, from March 12th, that first emergency order till June 30th of 2020, if you had a confirmed test or signs and symptoms that were diagnosed as COVID, this presumption will apply to you. Now, after June 30th, so July 1st until the end of last year, you have to have a confirmed test. And I think the difference, obviously, there is kind of what Craig was talking about, is the testing got better as time went on. And so they expect some sort of absolute objective test after July 1st in order to get the presumption. That's kind of the law in a nutshell. It gets more complicated as things, as it gets litigated and different opinions come down. A lot of this will change. A lot of different various details will be ironed out in terms of the language of the statute, but those are the real basics. So again, if you had COVID, if you had to seek treatment because of COVID and missed work because of it, anytime from March 12th to December 31st of last year, odds are you're going to be able to take advantage of this presumption. So what do you do about this? Well, like any comp claim, you're going to have to file a claim for benefits. Kristen, I had provided you, and I think she's going to provide it to everyone, just the standard claim for benefits document off the workers' compensation site. It's a little bit terrifying looking at it. There's just so much involved in it. So again, I always urge folks to at least consult with a lawyer before you get into the weeds on these things, especially with the complexity of this statute. The other thing to note too is that there is a deadline. So any occupational disease, including COVID-19, you have 2 years from the date the diagnosis was communicated to you. So that would be essentially, in this case, the date that you were given a positive diagnosis. And you kind of see that in the red square that I highlighted is where you would fill out the occupational disease pieces of it. But it really is as easy as filing a claim with the Workers' Compensation Commission. Again, sounds easy. It gets a little more complicated when you get into the details and the nitty-gritty on it. So,
and we'll send that out after the webinar to everybody that registered.
Yeah, and also for your information, and I don't think you all will want to read it. That's probably something that's preserved to folks like me and Craig for a living. But I did also provide the edited statute. The reason I wanted to provide that is you all are entitled to many different presumptions, including some, exposure to HIV and some different other communicative diseases as well. So this isn't necessarily a new thing. It's just meant to make sure you all are protected in the event that COVID-19 has affected you in bad ways, which I'm sure it has. So anyway, that's kind of the 30,000 foot view. I'm happy to answer any questions. Craig, I don't know if you have anything else you want to throw in, but Kristen, I don't know if you want to.
Yeah, we did have a few questions, but Craig, did you have anything you wanted to add first?
No, I think that's good. I think, look, I'm a skeptic when it comes to the sausage getting made as part of government, and I hope this holds up. Casey alluded to it. There's an argument that these legislators, they have a lot of different people in their ear, and we're the way this is going to be attacked is the retroactivity part. I think anybody who gets it after that effective date is going to do okay with their case. What worries me, there are some old laws that say only certain kinds of statutes can apply backwards in time. And so I think the insurance companies, for hospitals, for counties who employ police officers, they're going to argue that the statute doesn't fall within that narrow scope of statutes that can go back in time. That might be where the fight is, or it's going to be where the fight is. But look, is this better than nothing? It is. It is. We've got something here, and we're going to make the most of it and try to help as many people as we can. I can sit here from 30,000 feet and armchair quarterback and say it could have been done better, and we could have made it a little tighter and not leave the insurance company a loophole to argue with. But we've got something in a relatively reasonable amount of time in the face of a lot of different competing interests that were all happening at the same time.
We sure hope it sticks. So there were a few questions. One was from an individual who was working, let me see. She said, if you could explain exactly how this law protects those who contracted COVID-19 while employed. I'm asking because I had a court hearing, and obviously this was before the law has gone into effect. And the judge basically ruled, even though I got it in April, that it was community acquired. I was working with COVID patients at that time that were positive and negative while reusing PPE.
Yeah. So we advise people, different groups and other lawyers to not file these cases. And before this law took effect, or before some law took effect, because we thought that 99.9% of them would lose. And the reason, as Casey went into, is all the insurance companies and their lawyers have to do is to prove that the person was exposed in some other area or could have been exposed to some other area. Well, based on what we knew, let's say last April, I could have gotten it, opening a door handle. I could have gotten it in the grocery store. I could have gotten it filling my car up with gas. So any of those other, unless you lived you were the boy in the bubble and lived in the bubble everywhere else other than work, it's really shooting fish in a barrel for them to say, did you ever go outside of your house? Were you ever within 6 feet of somebody else, anywhere else other than work? And as soon as you admit yes, because all of us were at some point, then you can't prove and meet your burden of proof, which is to rule out any non-work related cause.
So will they be able to refile the claim?
I don't, if they've gone to a point where it's been adjudicated, and by that I mean they've had a ruling, I don't think you get two bites at the apple. I think that those rulings where a work comp commissioner or deputy commissioner has issued an opinion, I think at that point your case is final. I don't think you get to go back with a new law.
And again, every case is going to have so many various details. I just want to make sure, don't take anything we say as 100% Bible. I think Craig's right there. But again, if you have any questions at all, it is, I think, important to speak with someone who knows workers' comp and can navigate you through, even if you've had something like a comp commission order, I think you still need to speak to a legal professional just to get some sort of advice.
That's a great point. I'm giving analysis here on
Sure.
a new law. I'm not giving any individual person, a legal opinion on their own case. I'm just taking a hypothetical and giving it some legal analysis.
Right.
But
Great point.
I just don't see. And here's an article I read in the paper today that's it's more analogous than you would think. People right now that are in prison for marijuana are saying, well, on July 1st, do I get out of prison? No, your case was decided under the law as it existed at the time. And so apply that to us. If your case was already decided based on what the law was before this law took effect and you were found to not be covered, I don't think you get to go back and have a second hearing or a second trial on it.
Okay. And speaking of finding a lawyer, one person had asked about how to find a lawyer in their area. So how do people find lawyers who might be able to handle cases like this, handle these types of claims in their area?
You want to find a lawyer who knows workers' compensation and knows it well, preferably one with a beard. And I got two great scenarios right on your screen for you right now. No, I'm kidding a little bit, but again, Casey and I are lawyers who are very experienced in workers' comp. You don't have to use us, but you can find it like you'd find any other lawyer. 10 years ago, I would have said you pick up that giant yellow pages and flip to the middle. Now it's you Google it or you look for an ad somewhere or you ask somebody who's been represented before. I mean, I've had a lot of nurse clients. Nurses have to do a lot of heavy lifting and I can't tell you all the shoulder and knee and back injuries I've represented nurses on over the years. So you just find somebody who can recommend you or you look up and find a lawyer, but you want to find somebody. One of the biggest dangers in workers' comp is lawyers who do other things think they can do workers' comp. I call that, I think Casey does too, we call that dabblers. They dabble in workers' comp. You don't want a dabbler on something like this. You want somebody who does it 24/7.
Yeah, and shameless plug adopted on my end as well, but I will say that it is important, especially in this scenario, because it's new. It's going to be litigated to the hilt, that you find someone who's really experienced in workers' comp. And again, I think probably Google and doing your research on on any attorney you pick, and what kind of experience they have with comp is the most important thing for choosing.
Okay. One person is asking if this law will if it's specific to private, state, and federal employers.
Yeah, and I meant to address that question. Yeah, it's only, so workers' comp state law only applies to state and private folks in Virginia. Federal comp has its own completely separate set of laws and administration. I honestly don't practice in that area because it's so different from us, and I'm not sure how they're handling COVID-19 claims at this time. But anyone who works for a state hospital or works for a private employer in the state of Virginia, there's some other caveats there, but mainly, yes, you will be covered by these laws.
Okay. And one other question I have, and then there might be some in the chat feed. Are there any resources for nurses that got COVID while working and had to use personal time or vacation and now don't have the hours to take any actual vacation?
Yeah.
So, oh, go ahead.
Yeah, see, file a workers' compensation claim. So here's what happens. If you are successful in a workers' compensation claim, and you may shy away from filing the claim because you're like, well, I use my PTO time, I'm good. Well, if you were successful in your workers' comp claim, the insurance company and your employer have two choices. They either pay you again the workers' compensation benefits you're owed, or they're required to recredit your PTO time. They get the option of which one of those they do, but they have to do one of the two. And I filed cases, won them, fought them. I thought everything was fine. And then my clients come back to me a year later and said, hey, I never got paid or my time back. So we've had to go fight that a little bit. But you're entitled to one of the two. Either they double pay you. So in other words, you don't get the PTO time, but you get to keep that money and get paid workers' comp benefits on top of it. Or they recredit your PTO time.
Okay, but if the claim is unsuccessful, then no.
Then you're right where you were today.
Right,
With,
right.
you've used your PTO time.
Okay.
Correct.
And there was one other question that was, some employers are saying we have to prove exposure in outpatient settings, such as radiology diagnostics. Is the burden of proof on us, and to what extent, and how do we prove this?
Yeah, so the burden of proof is always going to be on a claimant in workers' comp cases. However, this law kind of flips it on its head, where the presumption is in the claimant's favor. And employers, I'm not sure what their point is on proving in an outpatient way or whatever, but this law is going to kind of change the entire way, the lens through which everyone views these claims, because it sets out exactly how you get the presumption, and then if it's rebutted, it'll be through other evidence that the employer will have to.
Yeah, lawyers always use the scales argument, right? And so what it normally does is your scale is lower and you've got to build evidence to go up. Here it's the opposite. The presumption means we start ahead, and then they have to. Now look, if you were in a radiology lab and I don't know how anybody could do this, but they could somehow come in and prove that no one that had COVID or carried COVID ever came into that lab at any time you were in there or within a day of it in any way, shape, or form, then that would potentially rebut that presumption. But I don't know how they do that. That would seem to be a tough haul for an insurance company to do. But you're starting out with your presumed, if you meet those tests, you presume to have gotten it at work.
Okay. And Kristen, do we have anything in the chat feed?
Yes,
Some things pop up.
we do. Can you see it?
Let me
Oh, there it is. Okay, and this one is from Holly. Hi, Holly, glad you could join us. Holly has long COVID, and she says, will the fact that I haven't worked since July 27, 2020, will I be covered for the entire time just when I had an active case of COVID? I was working for my company for 2 months and had no benefits until I was there 3 months. Will I be covered under workers' comp? She says, I got fired because of getting COVID because I had no benefits like PTO or FMLA.
So yeah, I was just going to say, so here, this is a good example of, I don't want to provide any specific advice on a specific case, because again, there's various factors. But if your out of work is related to the condition you have, whether it's long COVID or it's a short course of COVID, you will be entitled to wage loss replacement benefits during that time. Now, there are certain things that can cut off your benefits, such as termination for cause and some other various things that are not new. They've been around in workers' comp law forever. So again, there's other things that could affect the viability of that. But on the whole, again, 30,000 feet, yes, you should be covered under comp for those times.
The only thing I would add to that, to be covered, you would need a doctor to have
Correct.
written you some type of note, letter, whatever, that says you are unable to work. It couldn't just be you coming in saying, boy, I was really tired, I couldn't work. That's not enough to get you there. But with a doctor's note that says Holly or whoever has had long COVID has been unable to work for the last 8, 10, 12 months, then that would be enough. Once you establish your entitlement and prevail on showing that you meet the statute, you would retroactively get those benefits back to whatever date the doctor took you out of work.
All right. And
I got
yes,
a question sent to me, and this is from
Sure.
someone who wanted me to ask on their behalf. It says that we were told to file a workers' compensation claim, or suggested to, when we were out for a longer period of time because of COVID. This was prior to the bill being passed. And if that claim was denied, is the recommendation that I seek legal advice at this time?
It is to seek legal advice. I think the key, again, as a hypothetical, without giving any person specific advice on that, what I would say is, when you say it's denied, that means a lot of things to lawyers, maybe different than sometimes to the person. If you just mean the hospital's insurance company said your claim's denied, that's just a piece of paper that some jackass with an insurance company sent you. It doesn't mean anything. So yes, your claim has not been adjudicated yet. No court has decided that you've lost. If by denied, you mean I filed my claim, I went to a hearing, the judge ruled against me, then you're likely in that situation we discussed earlier where you've had that bite at the apple and aren't going to be able to revive it under the new statute.
Got it.
All right. Did you have any other questions you received, Kristen?
They all pretty much have been answered. They're pretty,
Okay.
there are a couple that were really highly specific and
Okay.
apply specifically to that person's individual
Sure.
experience. So I recommended that that's something that they probably would need to speak with someone about.
Absolutely.
Personally.
I
Great.
see the person who asked the question earlier, I see right now popped up on my screen. How do I file a claim with the Workers' Comp Commission? That's a great question. So there are multiple ways to do that. The easiest way in the age of computers is to just go to the website and you can file a claim online through the web file system. You could just, that form that Casey showed earlier, there's an online version. You can populate the blanks and fill it in that way. Or you could print that form, fill it out, mail it in, print it, I think, or you can go by your local closest workers' compensation office and file one in person. So there are multiple ways to file the claim. The easiest, don't leave your couch way would be the online version.
Great. Well, I see we are at 3:32. So Craig and Casey, I want to thank you so much. And thank you everyone for attending today. I think this has been a lot of great information to help navigate this new law for everyone. And again, we did record this and we'll be posting the recording as soon as possible and sharing the link on our social media platform. So with that, have a great week, everyone.
All right.
Thanks again.
Thank you.
Thank
all.
you. Take care.